Hi, everyone. This is Sam Silverman, Managing Partner of EB-5AN. On today's webinar, we're going to discuss EB-5 for Canadian citizens. Specifically, we'll talk about how to relocate to the United States immediately and never leave. And obviously, to make sure that this works, you need to be represented by experienced EB-5 immigration counsel to make sure the process goes smoothly. And today we have Anita George, one of the top EB-5 attorneys with us today. And in a few minutes, I'll introduce her and we'll get into the topic of today. This is a quick overview of what we're going to cover. We'll talk a little bit about EB-5AN. We'll introduce Anita George. We'll talk generally about source of funds and why investors need to understand what documents are required to make an EB-5 investment. We'll talk about the new adjustment of status policy that allows investors to move to the US and effectively never leave. We'll talk about some special rules for Canadian citizens, and we'll talk about how Canadians can qualify to adjust status and obtain a flexible work permit EAD and advanced parole travel document in just a few months. And then we'll conclude with some discussion around some available EB-5 investment projects open today at the $800,000 investment amount. A little bit about EB-5AN. We're a leading EB-5 investment fund manager. We've worked with thousands of families over the years and investors from more than 60 different countries. We have more than 10 regional centers that cover 48 states, and we've been working with EB-5 since 2013. One of the things that sets us apart from many of our competitors in the EB-5 space is a total focus on EB-5 investment transparency. So our goal is to make sure that investors have access to all of the data, all of the information, financial statements, disclosures, everything that we can possibly think of related to an investment, and also related to the EB-5 immigration program generally, current events, things that are happening, data, and our predictions and opinions on that information so that investors can make a fully informed decision on both whether EB-5 is a good fit for them in general and also with respect to areas to focus on when considering particular projects. This is a map showing where many of our investors have come from over the years. Most importantly here is that people of many nationalities and backgrounds have consistently found value in our investment approach to the EB-5 program. And as I mentioned earlier, we have complete coverage of the continental United States, which means that we can be very discerning and strategic about which EB-5 projects we select because we could do a project pretty much anywhere in the country. As I mentioned earlier, I'm Sam Silverman, one of the two managing partners. A little bit about my background and experiences there on the left-hand side of the screen, and my partner Mike Schoenfeld on the right. We come from institutional management consulting and investment backgrounds, as you can see, and we've been involved in some of the largest IPO and LBO transactions over the last 15 years. Okay, and now I'm pleased to introduce Anita George, one of the founding principals of George and Marcialo Attorneys at Law. Anita is one of the most respected EB-5 immigration attorneys with a focus on EB-5 specifically, and I'll let her jump in and introduce herself and share a little bit about her experience in EB-5. And also talk generally about why today is really a good time for investors considering making EB-5 investments.
Yeah, thank you, Sam, for inviting me. Hello, everyone. My name's Anita George, and as Sam mentioned, I'm the founding partner of George and Marcialo. We are a Seattle-based boutique law firm that specializes solely in EB-5. As background, I was a forensic accountant and a tax attorney that worked at 3 of the Big 4 accounting firms. So forensic accounting is my bread and butter, which directly weaves into the EB-5 petition, where we're convincing the US government that all the money invested in these projects are clean and have been properly sourced. Just for context, an average EB-5 petition is about 3,000 to 4,000 pages long. For clients that are based out of Canada or the US, the document retention period in both these countries is 7 years. So we're basically providing 7 years of visibility, going through your data for over 7 years, and telling your story to USCIS in a way that they understand. We've been doing EB-5 for over a decade. We've done over 700 EB-5 immigration petitions, and we have a 100% approval rate. I am an immigrant myself who's a naturalized US citizen. We have attorneys in our firm that are fluent, including myself, in Hindi, Gujarati, English, Spanish. So we speak multiple languages, and we have represented clients from Canada, India, Philippines, Vietnam, Australia, Europe, most of the countries in the world. So again, 700 petitions. We are an independent immigration attorney, which means we do not represent regional centers. We exclusively represent the EB-5 investor. So we have never had or will never have any conflict of interest in working with clients, whether they work with EB-5AN or other regional centers. We do not have exclusivity with any of the regional centers. In terms of answering Sam's question on EB-5 today, I would definitely say that since the passage of the Reform and Integrity Act, EB-5 has become a better program, not just because of the benefits that clients that are in the US are immediately getting, which is the ability to adjust status, but more because the integrity reforms that were put in, the fund administration reforms that were put in. I think there's more scrutiny on the program now than there ever was. You know, disclosure of fees that are being paid to agents, all of that is now more of a transparent process. I think Sam will agree that prior to 2022, we were all operating in a black hole. I didn't think clients knew that they were being, you know, sold a product by a broker. I think now there's more awareness. Clients understand what the broker's comp is, what percentage is going, how they can negotiate on fees. I think there's a lot of transparency, and by that, we've seen better projects come on the market. And of course, the added benefit of rural priority processing. In the last 3 months, we've experienced, just by calling out Twin Lakes, since I'm on an EB-5AN webinar, we've had close to 17 approvals on files that were filed between November 2022 and April 2023, which is an incredibly fast time, while we still have files that are pending under the old law from 2019 and 2020. So I think that this change in the program has been remarkable and really positive.
Perfect. That's really helpful. I think, but before we dive into the main topic of today's webinar, you know, specifically about Canadian clients, you know, wanting to take advantage of EB-5 and come to the US quickly, let's speak a little bit about just source of funds generally. You know, what is source of funds? Why is it important? And how does it fit into the decision to make an EB-5 investment? And how does an immigration attorney, what role, you know, does he or she play in that component of the application?
Yeah, I think that's a great question, a very loaded one, considering that these files vary from source to source. Very high level though, the US government wants to be convinced of two things. The money were sourced using legal activities and that taxes have been paid. Generally, when clients come to us, they assume that just providing tax returns or W-2s is good enough to establish legality of the funds invested. That is not the case. Often the initial round of consultation is us educating the investor that we cannot just produce tax returns, we cannot just produce W-2s, we cannot just provide sale agreements of properties and say, hey, I made this money off of the sale, or my W-2 adds up to $5 million, hence I've invested $800,000. The government wants us to go through your bank records and show them the deposits of salaries or business income, how that wealth has been accumulated and maintained over a period of time until it's been invested into the project. This requires us to go through, usually on any case, 7 years of documentation, unless you're a high-paying CEO who got a massive bonus for $800,000 and is investing those money. Most EB-5 source of funds are a combination of cash, sale of equities, debt, and gift. So the source of funds documentation then changes based on the asset that's being liquidated. We often get questions about, can you give me a list of documents? And that is very difficult to do because there's no standard list of documents. If you're liquidating equities, the list of documents is different than I purchased a property, I'm now selling it. Going back to the basics of source of funds, USCIS wants to understand how an asset was acquired, whether that's an equity, whether that's a home, whether that's any property that you're selling. What is very common with Canadian and US investors because of the appreciation in property prices is a home equity line of credit or cash out refinance. And here I'd like to focus in more on Canada and US to say that when you're drawing funds out of a home equity line of credit, the government needs to understand that the down payment was made from legal sources. And the way we do that is we provide the closing disclosure of the purchase to the government. We then tie that to your bank statements. For example, if a purchase was made in 2020 and your down payment was $120,000, we go back 3 years, show the payroll. We try and focus on deposits that were made before that payment was made for a down payment. We tie that to the closing disclosure. After that point, we start highlighting mortgage payments for every single month since it's debt financed. After that point, we show a refinance document or HELOC document, draw off the funds from the HELOC, and then investment into the project. So it is a very dynamic process. There's a lot of back and forth between clients. And most clients have an average of 4 to 7 accounts, which means if there are ping pongs between the accounts, we need to provide visibility to the US government. Again, the government has no way of knowing you have 4 Chase accounts and 3 Bank of America accounts. If they see money coming from a random account that's not been disclosed, to them it's unauthorized illegal money. So the onus is on us to prove that the source of funds is clean. Up until this point, we haven't received source of funds RFE since the Reform and Integrity Act has been passed. Most of the questions in the RFEs that we're getting are the government lost the docs. They lost the subscription agreement. They lost Exhibit 22 to 36. So I think it's very important that whatever attorney you're working with has a verbatim copy of the file that has been filed with USCIS. So that response to that RFE is in less than 12 hours. You're just extracting the file and submitting it to the government.
And one thing that you touched on there with respect to the mortgage, payment documentation, can you talk a little bit about how there's a difference between source of funds and path of funds, and
Yes.
what types of information and documents are going to be expected, to be able to satisfy both of those aspects?
Yeah, definitely. So source of funds talks about how the money was generated, and path of funds talks about how the money moved through your account. For example, in the case of a home equity line of credit, most banks, for example, let's just say KeyBank, will say you need to open an account with our bank. The HELOC will be drawn into KeyBank, for example. You have a Chase primary account where you're pulling all the funds. So you move the funds from KeyBank to the Chase account. Then that Chase account's also infused with sale of RSUs, right? Then you show the brokerage account. That way, everything is pooling into your Chase primary account. From Chase, it's then being wired to the project. When the funds are wired to the project, there is a outward wire remittance receipt, which will show that the funds were, for example, invested in EB-5 Twin Lakes or EB-5 Keystone or whatever regional center you're working with. It'll show who the beneficiary is. It'll show who the originator is. And on the regional center side, for example, with EB-5 we tend to get a Fed message, which is a message from the Fed showing that the funds have been received from the investor for the benefit of this petition and into this project. Post which we get an escrow confirmation letter from EB-5 escrow bank. That is the entire trail. What we cannot do is say, we have a home equity line of credit, I've provided KeyBank, and I now infused EB-5 account. You're now missing the link with Chase. And if that visibility isn't available, you're going to have an RFE, or it's not submitted, you're going to get an RFE. So in my mind, just as someone who's done accounting in the past, auditing in the past, this is very formulaic. If it's done correctly, you are going to be approved. It's one of the few visas in the world where you do it and you know that it's going to be approved, or you know what questions are going to be answered, which is why I exclusively focus on EB-5.
Got it. Okay, so let's dig a little bit deeper and talk about just what are the major 4 categories that investors are obtaining funding from, and just kind of give us a little summary on each one, and then we'll talk a little bit about loans, specifically with interest rates.
Yeah, so definitely the most common source is ordinary income, which is your salary that we touched upon previously. W-2 or T4s in Canada exclusively are not enough, right? Visibility into your bank statement is extremely important because the government's looking for accumulation of wealth. If that money was taken and invested in a CD, or if it was invested in stocks and that's being liquidated and brought back into your account, the government needs to have visibility into the CD or the stock accounts. So that's ordinary income that's being invested in alternative assets or any assets that is then being liquidated and brought back in, which is the most common form of source that we see. I would say it's very rare that the files have one source. Most files are a combination of 3 to 4 sources. The next one is capital gains, which we talked about, could be in the form of stocks that were purchased and sold, or RSUs. We're based out of Seattle, so we have a lot of tech companies that award RSUs. We work with Google employees, NVIDIA employees, Amazon employees, Meta employees, VMware, Oracle. All of these companies are issuing RSUs. Sale of those RSUs then causes you to trigger a capital gain event, and then you invest those funds in an EB-5 project. Something I do want to bring to light is most of the time when the liquidation is done, it's in the current tax year. So the tax returns are not available at the time of filing. We have highly recommended our clients to produce the 1099s from the brokerage account as well as the tax return in the future. So for example, if you're filing in 2024, by April 2025, you now have the ability to upload these documents to USCIS portal to avoid RFEs, to make sure that there are no follow-up questions. The next source is gift or inheritance from family and friends. The one thing I want to touch on here is when this question is asked, if I can take a gift or if I can use inheritance money, the answer is yes. However, most of the times clients call us assuming that they can bypass source of funds. That is not the case. The same scrutiny that goes into an investor's source of funds goes into the donor's source of funds as well. Even if the asset was acquired 50 years ago, the government expects us to produce an affidavit from any living family relative who had knowledge of how that asset was acquired. If your grandmother purchased a property and you've now inherited it, you will need an affidavit from your father stating that my mother was a teacher by profession. We are outside document limits, retention period in Canada, hence we're not able to provide bank statements, but we attest that this money was legally earned and these legal funds were now invested for the purchase of this asset that now I have received as inheritance, and now I passed on that inheritance to my child who's liquidating it for EB-5. So we need to be very careful and go back to the inception of the source at all times, no matter how old the source. The final point is with gifts and inheritances is gift tax. For example, Canada does not levy a gift tax. We don't need to worry about that. However, we do need to educate USCIS on that matter. So we will then produce articles from PwC, KPMG, or the Canadian Revenue Agency's website to show that this gift is not taxable. Here are the laws. Within the United States, if a gift is being given, the donor is taxed on the gift. It's not a tax per se, however, it is a write down of the lifetime limit that you can give to your family. So for example, the current lifetime limit under the Tax Cuts and Jobs Act is $12.5 million. If you are gifting $500,000 to someone, that $12.5 million will be reduced by $500,000, and that'll be your lifetime limit. There is no tax levy. That being said, you do need to focus on state rules. For example, in Washington, gifts over $1 million are taxable at the state level, even though the federal law has an exception of $12.5 million. And the final point is loan from family or friends or companies. any loan that is sourced from friends, families, privately owned companies, publicly owned companies, we need to source the source just as if you were as an individual. Again, if the money is coming from a company that's an IT staffing company, we need to go through where's the business located? What's the business's website? What are the services that are being provided? Here's a copy of the invoice. Here are the P&L statements. Hey, the money is being given as a loan by the company. What are the terms of this loan? Specifically within the United States, the IRS requires that the loan have an interest rate. And that interest rate is determined by the annual federal rate that is printed on the IRS's website on a monthly basis. The reason for this is that there is no loan, right? Here's the table. If there is no rate, IRS can come and levy a tax stating that there is this benefit at a 0% loan that the investor is getting because the loan is at a 0%. And that benefit could be at 5.25%. And now that becomes taxable income to the investor. We've seen 3 RFEs in the past where it seems like the officer did understand taxation and asked us questions about whether the investor had paid taxes on the zero income loan or whether the person receiving these monthly interest payments was disclosing that as additional income. Everything is fair game when it comes to USCIS, so we try and prepare for this in advance so that you're not surprised in the future. Sam, just going back to gifts and inheritance, FBAR comes up quite frequently. If the gifts are being given for an account and the aggregate value of those is over $10,000, in the past we've been asked for FBAR filings because the law is that if you have foreign accounts with aggregate value of over $10,000, you're required to disclose it to FinCEN and FBAR, and those filings need to happen. So if you have a bank account in India or in Canada, but you reside in the US, you're doing business in the US, you will have to file FBAR and FinCEN. This is not always requested, but there are off cases where we have these sample RFEs where these requests were made. And if there is no answer for that, that could result in a denial for lack of compliance with local country regulations.
Okay, so for those of us who aren't in the details of EB-5 on a daily basis, one of the terms you mentioned was an RFE. What is an RFE and why is that a concern, and how do investors kind of try to avoid getting an RFE as part of their EB-5 process?
Yeah, RFE is a request for evidence, and we can try our best to avoid it, but there are times where USCIS has lost documents. That has happened in the last 7 cases where we just need to have a copy. But I do think that we do tend to go out of the way to anticipate what USCIS may request. Anticipations like tax returns, W-2s, 1099s from your brokerage income. If you've liquidated assets abroad, then providing those tax returns eventually. Something that we are now recommending clients to do is once the USCIS portal access is granted, which is something newly established by USCIS, and we'll talk about it on the next webinar where we talk about the steps of what happens when you file an EB-5. You get access to a USCIS portal where you can add your 526E case and upload additional documents up until the point of approval. So you could, a year later, upload your tax returns, your W-2s, your sale documents, which historically we had to ship to DC and hope that USCIS attached it to the right file. Now there's delays in 956F receipts. So when we're filing the applications without the receipt, we get the online access portal and we upload those. All of this is done to just make sure, go an extra step to ensure that there is no RFE issued in the future, because an RFE does kill a lot of time. Worst case scenario, best case scenario, you lose 3 to 4 months in an RFE. So we try and avoid that for our clients.
Got it. Okay, so it seems like the main issue is that if you get an RFE, it's going to delay the approval of your case, and so anything we can do, in advance to provide documents that we think might be requested, if we provide them in advance, it avoids that unnecessary back and forth of several months, basically.
Correct.
Okay, got it. Okay, all right. So let's move on from general kind of source of funds discussion and talk a little bit about this new adjustment of status policy, and what is it, and why is it new, and what are the benefits for investors, particularly as they want to try to come to the US and do so quickly.
Yeah, I think this is the best change that came about in EB-5. Prior to March 15, 2022, if you were in the US, you could only adjust status after your 526 petition was approved, which is the EB-5 petition with the source of funds packet. The good thing with the Reform and Integrity Act is it allowed clients to file the EB-5 I-526E application concurrently with their green card application, the work permit application, and travel permit application if their country of birth was current in the US visa bulletin. The country being current is a question for India, China, Vietnam. It is not so much of a question for Canadian clients. But as of today, the good news is all these countries remain current, whether it's India, whether it's China. So clients that are in the US that have been waiting 10, 15 years on these H-1B lines or are on the verge of losing their jobs now have the ability to apply for adjustment of status after making an investment in EB-5. The major benefit that my H-1B clients or my Canadian clients that are here on E-2 or TN or F-1 have gotten from adjustment of status is it stops the clock. What do I mean by that? Once you file your adjustment of status application along with your EB-5 application, you are no longer beholden to your H-1B visa, your TN visa, your F-1 visa, your E-2 visa. What I mean by that is if you're an H-1B holder and you have, for some unfortunate reason, lost your job, you have 60 days to find another job. If you're unable to find a job in 60 days, you either go back to your home country or you convert to a B1, B2 visa and keep looking for jobs for 6 months, which is very difficult to do in today's market. A lot of the companies, at least in the Seattle area, tech companies are refusing to sponsor immigrants because of the cost. Because of that, now clients have run out of options. Even if you do change your status to B1, B2, 6 months may not be enough of a time to find another job. However, if clients can get the money together, file an EB-5 petition with adjustment of status, the 60-day clock stops. You now have the ability to stay in the US and look for jobs. You do not have the ability to work until you get a work permit, but the good news is the work permits are being issued in 60 to 90 days, and USCIS has been incredibly efficient at issuing those. So the EB-5 program has been a great benefit for tech workers that have been laid off, for E-2 visa holders that are here on E-2 visas whose businesses were impacted by COVID and do not think that they're going to be able to get their E-2s renewed, or TN visa workers that have just heard that their company is cutting job. And so if you're here on TN, you now have the ability to adjust status if you have the money to do EB-5. If you're an F1, recently we had the H-1B lottery, and I know that a lot of people didn't make the lottery. The selection rate is 1/3, right? You have a 33% chance of making it to the lottery. Those kids also now have the ability to make the investment. Maybe you're getting a gift from your parents. Maybe you're getting a loan. Any of those measures can be used to stop the clock and continue staying in the US. Under the old program, you had no ability to do that. You had to leave the country, hope for EB-5 adjudication, get counselor processed, and then re-enter the country. So again, the beauty of EB-5 today is the ability to concurrently file if your country of birth is current under the US visa bulletin.
Got it. And with that, let's talk about what does that mean, current, and how does that fit into the visa bulletin, and why is that important also in the context of these new rural and urban TEAs?
Yes, so the visa bulletin is something that's published by the Department of Homeland Security on a monthly basis after the government counts the number of visas that are available. Visas is in green card. Like every visa, EB-5 has a cap on it. And because the rules changed and new lines were created in March 2022, the new lines are, as you can see, the rural line, the high unemployment set aside line, and the infrastructure line. Because of those new lines, now all the countries that were previously backlogged became current if you're investing in a rural or a high unemployment TEA or an infrastructure project. As you can see, the old unreserved category is backlogged for India to December 2020 and for China to December 2015. So like I said, I still have clients that have filed in 19 and 20 that are awaiting adjudication. Meanwhile, the rural clients have been approved in 9 to 12 months. They've gotten their 5-year work and travel permit. Some of them are on the cusp of getting their green card. It is amazing what the transformation to the EB-5 visa has done for all these H-1B clients, F-1 clients, students that are living here, and Canadians that are here on a business visa. As long as these dates remain current, which we do expect them to remain current for the next couple of months, clients are going to benefit by doing adjustment of status.
Got it. And let's talk about Siddharth, one of the many clients that you've helped, and just kind of share a little bit about what that process looked like for him, timing, and
Right. So I will caveat this by saying that certain jurisdictions are better than others. What I mean by that is in Washington State, our application support center is fabulous, and I will talk through what that means. Once we do the filing of your EB-5, along with your 485, which is application for green card, 765, which is application for work permit, 131, which is application for travel permit, all these documents are shipped together to Texas. Texas splits the file. Texas will send your EB-5 application to DC. They will send your adjustment of status to California, depending on where you live, and they'll send your EAD-AP to, say, the National Benefits Center or the Nebraska Benefits Center. These files are then divided. Based on where you're living, for example, if you're North Carolina or Washington, the application support centers that do your fingerprinting are not severely backlogged. Wisconsin, not severely backlogged. Those are the states where you do get your fingerprinting notices in about 2 weeks of getting your adjustment of status receipt notices. What that does is once you're fingerprinted, the background check just runs really rapidly, and you can get your work permit, travel permit within 45 days of that background check being completed. It is super helpful for clients that have heard about impending layoffs, for clients that have a spouse that's lost a job, for clients that want the ability to travel but are worried about going offshore, because if they go offshore and lose their job, now they're stuck abroad. So again, the timelines do deviate, but I would say the median timeline for approval has been 3 to 4 months, which is incredibly fast for USCIS.
Got it. Okay, that's what we're seeing as well, generally across many of our rural investor applications as well.
The one thing I do get asked, Sam, quite a bit is, and I do want to clarify this, is there a difference between, investing in rural or high unemployment TEA with EAD processing times? No, the EAD processing times, whether you go rural or high unemployment TEA, are consistent. They're the same. Government doesn't care. Another misinformation that's out there that I've heard is that if you have a 956F approved on the project, you're going to get your EAD AP much faster. That is not true. EAD and AP adjudication have nothing to do with your source of funds and have nothing to do whether your project is 956F approved whatsoever. Those applications are looked by separate offices. They do not care. All they're looking for, have you filed EB-5? Do you have an I-94 showing that you've legally entered the US? Do you have a passport? These 3 things are looked at. So it doesn't matter whether you're high unemployment or rural, doesn't matter if 956F is approved or not, processing times for EAD AP are same across the board.
Perfect. I'm glad you brought that up. That is definitely a key distinction that a lot of investors get confused with. So let's shift gears and talk a little bit about just specific rules for Canadians looking to come to the US. And what we want to get to is, if you're Canadian and you're in Canada and you want to come to the US, what are the different pathways kind of lead you from being full-time in Canada to, being full-time with a green card in the United States?
Right. Okay, so I would say that our third largest client base is Canada. We do, especially since the Reform and Integrity Act, we've been doing 1 to 2 Canadian files a month. We're very familiar with Canadian documentation, and there are one of two options when it comes to immigrating from Canada. Option one is you go through consular processing, which is where you're applying from Canada. Say you've invested in Twin Lakes, you get an approval in 9 to 12 months because there's no backlog. You are then approved, USCIS approves your 526E application, forwards it to a contractor that's called the National Visa Center. That process of transferring takes about 4 to 6 months. Once it's transferred, the National Visa Center issues what's called a fee bill. That fee bill is a $345 bill per person on that application. So if it's you, your spouse, and 2 kids, you'll have to pay $345 times 4 as a fee. You pay that fee, you finish your immigration forms, you provide birth certificate, you provide your marriage certificate, you provide a police clearance from the province you're living in. Once all of that is submitted, the NVC packages that as one document, sends it to Toronto Embassy, which then conducts the interview for the EB-5 visa holder. The interview is usually 5 to 10 minutes. All the embassy wants to know is, what projects did you invest in? Where'd you get the money from? And what do you understand about the terms and conditions of the project? It is more of a formality than anything else. That is the consular processing step, which does tend to take 18 months to 2 years for the entire step to finish from start to finish. The second option that Canadians have is if they're in the US or if they have the ability to come to the US, and we can talk about what options are available, they can come to the US on what's called non-immigrant intent visas. This could be your TN visa. This could be your E2 visa. This could be an F1 student visa. And again, with the caveat that Canadians don't need a student visa, they need an I-20, right? So it is an F1, it is a student visa, but it's basically adjudicated at the border. We can go through those in details. But once you enter the US on any of these 3 visas, you then have to wait 90 days. You wait 90 days because you do not want to contradict what you've said to CBP, Customs and Border Protection, at the border saying, yes, I'm coming for school, yes, I'm coming for work, yes, I'm coming for E2, and it is temporary. I don't plan on staying back. So within those 90 days, we recommend our clients don't take any action, whether it's liquidating funds. You can certainly start due diligence on projects, you can talk to the attorney, but we do not recommend signing any document that would have any indication that this process started within those 90 days. After the 90th day mark, these visa categories now have the ability to file their EB-5 along with the adjustment of status application, which would be the 485 application for a green card, 131 application for travel permit, 765 application for work permit. This is really great. Sam did a couple of filings for Canadians in Twin Lakes that were here on E2 visas. What we'll say is we got the receipts in 4 weeks, the biometrics are already completed, and the case is updated in 45 days. So these guys are now going to have their 5-year work and travel permit within 45 days of making the investment and filing the application. I will again give a disclosure, times vary. The median is still 3 to 4 months, which is amazingly fast for USCIS. The one thing I will say that I get asked by a lot of Canadians is, if I do file this adjustment of status application, now can I leave the country before getting the travel permit? And the answer is no. And here's why the answer is no. All these visas are non-immigrant intent visas. Once you file adjustment of status and you leave the country before getting a travel permit, you have abandoned your 485. You try and then re-enter. CBP sometimes has the ability to see what immigrant visa you filed, or if they ask you a question, if you have any petitions pending, you will have to lie. Once you lie, you have committed perjury. So in any of these visas, you have to assume that you're going to come in, wait 90 days, and wait an additional 4 months. If you do not have the ability to stay here, you need to go, you have a business in Canada, do not file for adjustment of status. You can file the EB-5, you can go back and forth between both countries. There are no restrictions after filing EB-5. You just cannot adjust status. But if you are going to file for adjustment of status, you need to wait within the US until you get that travel authorization to be able to cross the border.
Got it. Okay, so to summarize, for Canadian clients, they have the ability to enter the US with a visa waiver. They can stay 6 months, but a lot of times, you know, you want to retire, kids need to go to school more than 6 months. So 6 months isn't enough. They want to be here 350 days a year. And so to do that, they're going to have to get on one of these 3 visa categories first to be able to do the adjustment of status so that they can come in and then get the work and travel permit.
Yeah.
If they're not in a huge rush and they're willing to wait, you know, year and a half for their I-526C to be approved, then no problem. They can just stay in Canada, apply from Canada, and then once they get the temporary green card in their hand, then they can move to the US and then never have to return to Canada. These visas are basically an option to come in earlier before you get the permanent green card and then not have to leave once you've made your EB-5 application. So these are optional, obviously, not required. And depending on the age of the applicant, their educational history, willingness to go to school, ability to start a business, put together a business plan, you know, there may be a better fit of these. There's obviously different costs involved, but we've seen success from pretty much all of these categories to be able to successfully file for the work and travel permit and then, you know, eventually receive the permanent green card. So let's spend a little time kind of walking through each of these individually. So first, the F1. You know, what is F1 and how, you know, could this work, you know, for a Canadian client who's looking to do the adjustment of status?
So I think F1 rules for Canada are the most lenient rules across the world. So Indians have the ability to get F1, you know, Europeans have the ability to get F1, but the way it works in those countries is you have to schedule an interview. And once the interview is scheduled, you have to go to the embassy. You have to go through that entire process where you're asked questions. If you're Canadian, though, you are issued an I-20 by your school. What's an I-20? An I-20 is a document, which is an affidavit of support that is issued by the college, and it's registered with the Department of Homeland Security. It has the name of your school. It has the source of your income. So what it means is if the tuition for an entire year is $50,000, it'll state what the costs are of attending school, and it'll state who the sponsor of those costs are. You basically take that document that's issued by the college after you get admission, of course. You take that, and it has to be a full-time program. You're not qualified to do part-time programs. You take that to the border. They'll ask you questions about what program you're going to study, why, what are your plans. You answer those questions and you're generally waived through. You get an I-94, which is basically CBP stating we've granted you legal entry on F1, but you do not have to go through the process of a counselor interview like other countries do. It is a very easy option. We've had clients that are middle age, 45, that have wanted to always go to school, for example, to do like a real estate, you know, just do a course or a master's in real estate. They want to understand law, they want to understand contract negotiations. They can find a small school that's willing to issue them an I-20, attend school for 9 months, get their degree. 90 days after they enter, if they like it here, you know, they like the test run, they can then do EB-5 90 days after entering. Just again, I think it's very important to keep in mind that at the border, there can be no indication that you want to stay for an EB-5 or that's your future plan. At the border, this is about we are coming here for school, and once school is done, we will be leaving. A lot of the time, Sam, what we've noticed is the F1 is more of a test case for clients to check it out to see whether they're able to run their businesses remotely, if they're able to go back and forth, if they're able to travel, run stuff from here. And if that test run is successful, then they'll file for adjustment of status. In most cases, clients with very successful businesses have opted to do consular processing and go back and forth without restrictions. What I most often tell my clients is, give it a test shot. I don't want you to enter with the intent of doing EB-5. This is more of a test run to see if you can operate in the United States for 90 days. Because again, we do not want to lie at the border. The implications of lying at the border are a lifetime ban from the United States. So again, this is a test run. Come for 12 credits, see how it works, see if your family is able to adjust, see if you're able to, your spouse is able to run the business locally, you know, and if all of that works out, then consider EB-5.
Yep, and there are varying, you know, different types of programs. We've got, you know, some more details here, you know, of the different types of options, and we did compile a list. So if you are interested in a list of potential programs that we've seen investors successfully pursue in the past, please reach out to us. We're happy to share that. You know, and again, good example here, student comes in, they get an F1, and then they apply for EB-5, and then, you know, they pursue the green card through EB-5 after. So there's definitely a lot of different programs around the country where getting an F1 is not going to be that difficult. And like Anita mentioned, you can use this as kind of a test case, come in, see how it is, see if you like it, and then, you know, choose to do the consular processing later to give you the travel flexibility. Okay, so the second option is the TN visa. So what is a TN visa, and what's kind of the unique kind of aspect of this compared, you know, with the F1, for example?
Yeah, so the TN visa is only available to nationals of Mexico and Canada. This is basically created under NAFTA, where Canadian clients need to have certain qualifications and need to be on a list of a qualifying job. So if you have, for example, you're a software developer in Canada, you have that's listed as one of the qualified professions for TN visa. You have a sponsor in the US. It is as simple as taking the sponsorship letter to the border and saying, I'm going to the US for this job. I'm going to be a W-2 employee. For example, Amazon tends to bring a lot of Canadians on TN visa to the US. You're employed, you have an offer letter, you walk to the border, you get approved, you come in. Again, you're in Seattle, you wait 90 days, see if you like the weather, if you want to live here. You then can file for adjustment of status after 90 days. Usually what ends up happening is at the 90th day mark, we start working with the clients on their source of funds. We start working with them on their medical. We start working with them on their forms. We do this after the 90th day to just ensure that none of the dates predate on whether it's a subscription agreement, whether it's the medical exam or the immigration forms, predate that 90-day mark, because that could be a serious problem. So we wait for the 90th day, and we then start the process of doing source of funds, doing, you know, the immigration forms, the medical, all of that. Government looks at totality of circumstances again. So it's very, very important to, even if you're having conversations with regional centers, not sign any documentation until you hit the 90-day mark. TN, just like F1, is very easy. The downside, of course, is your profession needs to be listed as a TN eligible profession, which is printed on the government's website. It's easily available. And also you need to have a job offer, and you need to be employed, right? So what you can't do is, hey, I'm gonna work for my uncle. I crossed the border, but uncle's not running a payroll. That's a problem. You need to be a W-2 employee that's being paid on a regular basis in case we're asked that question at the adjustment of status adjudication phase. I can talk about the general, yes, these are the job qualifications or statuses that qualify for TN visas. And we do tend to see a lot of engineers use it.
Got it. Okay, that's super helpful. All right, so let's shift to the last category. So the E2 visa. This is definitely, you know, what we've listed as kind of the more difficult of the three, and also the more capital intensive. But yeah, let's still spend a few minutes and talk about this and see, you know, how this would work if you wanted to go for the adjustment of status.
Yeah, the E2 definitely takes the longest to plan for and to file and to get approved. So it doesn't really work for someone who's looking to move immediately, right? Because you'll end up spending 3 to 9 months just getting this thing set up. And at that point, our recommendation has usually been just file the EB-5, right? And that in those 9 months, you'll probably already be adjudicated. But there are clients that still want to try for an E2 visa. And E2 visa is basically a business visa where you're telling the government, I'm going to spend, and the threshold is $100,000, at least $100,000 on this visa. I'm going to, for example, acquire the Subway franchise, spend $100,000. After doing that, there's going to be enough money to pay myself and a couple of other employees, and this will be a successful business venture. Once this is approved, again, it's taking anywhere from 4 to 9 months to be approved. Once this is approved, then you can come to the US. Say it takes 9 months, you come in, you now have to wait 90 days in order to now file for your EB-5. Sam, what we've heard constantly is clients wanting to do E2 to EB-5 conversion in direct projects. What I mean by that is they've done E2, it's a brand new business, they've done it in a high unemployment TEA area, and they want to expand it, right? Saying, I will make this an EB-5 business. That works very rarely. And the problem with that approach is job creation. In a direct EB-5, you need to hire 10 full-time employees at 35 hours per week. That bar is really, really high, especially for a new business. You have no way of knowing whether that business is going to be able to create those jobs. If you do end up converting your E2 into EB-5 into your direct project, and you don't end up creating the jobs or don't end up meeting that target, what could happen is you've gone off the E2, you're using the EAD-AP under the guise of your business is going to be a successful EB-5 business. The government comes back with an RFE saying, you in your business plan stated that you will have 10 full-time jobs by year 3. We're at year 3. Can you please show us that you have 10 full-time jobs? If you do not have that, you've given the government grounds for denial, at which point you had no underlying visa. You were just waiting on your work and travel permit, and you may have accrued illegal time. So what we tell our clients is we understand the urge to use the money, to make money off of EB-5 money, but it is a big immigration risk you'll be taking and converting that E2 into EB-5. So the fail-safe approach is keep your E2 business separate from your EB-5 investment. Rely on regional center investment where job creation is solely based on dollars spent, and use that approach. It is much safer when it comes to immigration. And yes, there's going to be opportunity cost, but at least you will not have accrued illegal time in the US.
Got it. Okay, that makes sense. Mm-hmm. All right, so but before we have some kind of concluding thoughts and a few other questions for you, we'll just share a few of the current EB-5 projects that we have available at $800,000. And then we'll get to a few other questions. So currently we have 3 different rural projects available, and I'll go kind of right to left here. So our Walhalla, Utah project is a 956F approved project, meaning the government's already reviewed the application and approved it. That project has many 526C investor approvals already, many lots already sold. Hundreds of jobs already created. It does qualify as rural, which means you get the faster processing and access to the 20% reserve visa set aside. And then in the middle here, our Kindred Keystone project. This is a condominium hotel project with a prime location right next to the gondola in Keystone, Colorado. Over 70% of the condos already sold, over 1,200 jobs already in place, enough jobs for all the investors already. And then our most popular project in the rural category is our Twin Lakes, Georgia project, which we mentioned earlier. It's a large active adult single family home project just outside of Atlanta, Georgia. Over 600 homes already sold, almost 500 already built and delivered to buyers, over 3,000 jobs already created, prior funds with 956F approval and many 526Es as well. And then shifting down toward the bottom here are 2 urban TEA projects. And again, these are projects that are not rural, which means it's going to take longer for the temporary green card to be approved, but the work and travel permit, EAD, AP, will be the same as though you had invested in one of the rural projects. This is basically one development. It's a apartment building in South Florida, very close to the beach. And this project is also catered to the active adult market. So 55 and up is the target clientele. And there are 2 different options. One is a loan with a 3+1 term, and the other is a equity investment in the same project with a much higher 5% annual return and about the same kind of 3 to 4 year target investment period. And Anaida, I know over the last couple of years you've represented clients in pretty much all of these projects. How would you say the kind of preference breaks down across projects based on country of birth of the investor and their desire to really get the green card as quickly as possible versus get the capital back faster or get a higher return? How do those, and also, are they in the US or not? Can they adjust status? How do those kind of different facts and circumstances for clients in your kind of experience, how have those things kind of incentivized investors to go with some of these projects versus others?
Yeah, I would say, Sam, that to start off, COVID was a teaching moment for a lot of us, immigration attorneys and previous EB-5 investors. And I say that because when the new rule was passed and we had just gotten out of COVID, I think one of the things that I was educating my clients on is, if you're going to go into projects, we want to make sure that the jobs are in place. And I think that with most of EB-5 AN's offerings, the jobs are always in place. Of course, Boynton is an exception, but you also have a track record of doing, say, 15, 16 projects with Coulter in the past that have been successfully completed. All the funding is in place. So when we start discussions with the client, that's where we say is, yeah, we want to make sure that the jobs are there because we have no idea what's going to happen in the future. If there's an economic downturn, the first thing you can do is protect your green card. Then we drop down to the rural and urban TEA discussions. I will definitely say that people were skeptical when the new law came out as to how quickly rural was going to be adjudicated. And I will say I was the first one to be skeptical. I did not expect approvals in 7 and 8 months. I was estimating 2 years. So the initial round of investors were definitely preferring urban TEA because there were more projects on the market. But the initial set of investors that ended up in all the rural projects, which I have a lot in Twin Lakes and a couple in Kindred, have benefited massively. We have all the way until April 2023 filings that have now been approved in record time, right? So I will say that a lot of Indian clients or clients that are born in India and China lean towards rural projects. We've seen, though, Canadian investors don't have a line whether they go rural or they go urban, so they're more open to evaluating both. For example, there's data from IIA that came out, and this is something I highly recommend all clients to look up. AIIA is a nonprofit that did a Freedom of Information Act and got all the data on how many applications went into rural filings, how many went into urban, and there's a breakdown for India and China and rest of the world. The rest of the world piece is very tiny. So I definitely think that India and China, if you look at the data from the last FOIA, for every 1 application that went into rural, 2.5 went into urban TEA. So Indian clients, Chinese clients definitely have a heavy preference for rural, and we've seen the results of those. Meanwhile, clients from Europe, from Canada, people that are born in Australia can afford to go in an urban TEA project and benefit from the 5% return, right? They can benefit. they're going to wait the same amount of time, whether they go rural or urban. It's not going to matter which line they pick because they're not getting filings by droves. So we've seen people all over the place. Recently, what we've seen is clients that are within the US are willing to be on a work permit, travel permit for a longer time, just so that their opportunity cost isn't zero. So for example, if you're in the US, you're getting a 5-year work permit, travel permit. Even if you're waiting 4 years for a green card in urban TEA, you're going to get 5% if you're investing in Bulletin. So those calculations are being made by people that are in the US on, say, H-1B, TN, E2, F1. They're saying, I'm already getting the benefits of a green card through the work and travel permit. I might as well get that preferred return by investing in Bulletin.
Got it. Okay, that makes a lot of sense. All right, so I think to just kind of share some overall concluding thoughts, what would you say is kind of critical for investors considering making an EB-5 investment, in the landscape today? Like what are the things that investors really need to look for, both in terms of diligencing projects and then also in terms of, selecting an EB-5 immigration attorney to help them through the process?
The one rule I tell my clients is I will not work with them if they haven't talked to 3 other attorneys. So they do understand the depth of the knowledge every attorney has. I do think it's very important that clients interview multiple attorneys and ask very relevant questions. One of the questions I would ask if I was the investor is, have you ever represented a regional center? Have you ever done documentation for the regional center? Would there be any scenario in which you would be conflicted, you would have to withdraw your representation from my case because you worked with a regional center? How many files have you filed? Have you filed under the old rules, new rules? The number of files is important because it means that that attorney has seen multiple scenarios, RFEs. RFEs guide us on our future filings. For me, doing EB-5 for over 11 years, I now have a roadmap of any and everything USCIS can ask for. And so it's then that knowledge is built into the source of funds without having to wait for USCIS to generate an additional RFE, right? For example, initially we started getting RFEs about 956F receipts and subscription docs that USCIS was losing. We improvised. What we did was we started uploading those documents to the portal, even though they were submitted in print, in case USCIS lost those documents. Similarly, with the tax returns, if you have a massive capital gains bill, we tell our clients we want to make sure that the following year the taxes are filed and they're uploaded. So we want to stay a step ahead of USCIS. Those are conversations you can have with your immigration attorney. Understand how many regional centers they worked with. If one particular attorney has just worked with one regional center, you have a red flag, right? We've filed with all 10 regional centers across the country. It doesn't matter to us where the investor goes, and that's how it should be. We're only looking out for the client's best interest. We're not telling them where to invest. In terms of regional center, the golden rule I tell the clients to follow is always request all the offering documents. And I know this is a very scary proposition for the investors because the offering documents comprise of a PPM, right, which is a placement memorandum, a limited partnership agreement, articles of incorporation, business plan, loan agreement. All of this is very overwhelming to the investor. And all I say to them is, one, if a project is unwilling to share those documents, that should be your first red flag to begin with. The client has the right to look at these documents. I also encourage all my clients to read those documents. I don't think everyone needs to read 200 pages, right? I think they can read the first 10 pages and get an idea of what the project is, what the term is, how many jobs are there, at what stage the project is at, what are the terms and conditions of redeployment. But we do insist that our clients request documents from the regional center and read those documents. And the third thing I recommend to my clients is we urge the clients to ask questions in writing. I have noticed a pattern where the client wants to ask questions and they put it all in writing, and then the next thing you know is the client gets a call, hey, I think this is easier to discuss on the phone. I understand that it is easier. And if you want to discuss that on a call, that's all right with me. But I do also would want the regional center to respond in writing so that there is written record of what was said tied directly to the offering documents. I do think that the client, the consumer is the king. So all the power is in the client's hand. And so they should not be shamed into doing something. If they're requesting a doc, the doc should be provided. There should be full transparency. And finally, the investor should not be forced to use a particular attorney. If the regional center says, we have exclusively partnered with this attorney and we will only work with this attorney, I think that's a red flag. The client needs to understand why that is the case and why they're not free to choose their own lawyer, understand the relationship between the attorney and the regional center, whether there is any compensation structure between both those entities. These are the four golden rules I feel like every EB-5 investor should be following.
Got it. And those all make sense. And obviously with EB-5AN, we're happy to make all documents available, no issue, along with all the financial statements related to any of our investments. And obviously you can choose to work with Anita, you can choose to work with John Smith, you can choose any attorney that you like. There's no restriction whatsoever. Obviously, we have a lot of experience with different immigration attorneys over the years, and we can point you in the direction of a few attorneys that we've seen other clients have success with. But at the end of the day, it's your money, it's your decision. And so, you get to pick which attorney is going to be the best advocate for your personal application. That said, I do think, Anita, could you share a little bit about kind of your working style, how the onboarding process works with clients? If a client speaks with you, two other attorneys, what kind of differentiates your approach from some of the other EB-5 lawyers in the space? And when a client is ready to sign up, walk us through that kind of process and what it is like, working with your team to get an application done.
Yeah, so there are many respected EB-5 lawyers in the game. Absolutely, EB-5AN recommends some of these really, really great professionals that have a great stellar track record. I do think we're a younger firm, so we tend to rely on technology heavily. Once the client wants to sign up with us, if the client is active on WhatsApp, we tend to have a WhatsApp group with the entire family. So whether it's the parents or it's the couple, depending on what the client wants, there's a WhatsApp group that's created. Through that WhatsApp group, we collect information, just basic information like name, number, email. We then create a Dropbox account for the client where we upload the retainer, we upload the invoice, we upload checklists for adjustment of status, we upload checklists for source of funds. And again, the source of funds checklist is customized once the client retains us, tells us where the money's going to come from. So that list takes about a day or two to be generated. All the documentation is electronically uploaded to Dropbox. We never require physical copies of any documentation. We also send out questionnaires through electronic portals for immigration forms. So we're not asking the client to fill out paper forms. We're not saying go fill out the immigration forms by yourself. We have a custom created questionnaire for the clients. Clients fill that out and we use that data to then populate the immigration forms. We have a very open and transparent process. What I mean by that is everything is done over Dropbox and client has the ability to look at the immigration forms we're working on, to look at the filing copy that we're working on, to look at the cover letter, to look at all the exhibits that are being built and give us comments in real time through the Dropbox app. And we then respond to those comments in real time as well. I think that's what differentiates us is that our turnaround time for a US or Canadian file is usually 7 to 14 business days, which is the fastest of anyone in the industry. We have had cases in the last month and a half, Sam, that you were aware, Amazon had a bloodbath. They laid off a bunch of people and we filed files in 3 to 4 days where we were going all-nighters with the client, getting their documents, compiling 3,000 to 4,000 page files. And this isn't sloppy work. This is just everything is very formulaic. There's no source we've never seen. There's no problem we've never encountered. So we know exactly what to expect and we know exactly what to request from the client. And that really speeds up the process. And in those days, clients are also motivated to get this process out, right? So we've turned files around in 3 to 4 business days. And it's great because we also need a responsive regional center on the other end. So like, for example, with EB-5AN or other regional centers, we're able to communicate on WhatsApp and say, hey, we need the subscription doc countersigned. We need an escrow letter. This person is ending their 60-day grace period. Can you please help us with ABC documentation? It's very important to have all parties work together, without any friction, because that's how the file gets done. But our reliance on, electronic method of communication rather than, hey, the client sends out an email, we wait 24 hours to respond. We have a live WhatsApp chat going on. Alternatively, in the past, we've also used Slack, and every client has their own Slack channel so that in real time, there's a lot of back and forth. But we never have a situation where the clients have given us docs and we're waiting for 4 weeks to process them. If anything, we're usually the ones chasing the clients to get the files done. It's a very enjoyable process for us, and I think clients also like the fact that they're not waiting 6 to 8 weeks for their file to be done, or 6 weeks later hearing that document ABC is missing, right? That's not our strategy. We're a boutique. We only do EB-5. That's our sole focus. So at any given point a week, we only take a limited number of files and we churn them out. Client has a copy of what was filed. Client can see if any mistakes were made. Client can give us comments, and that work product stays with the client until the end of the process.
And I think one of the things that I've heard just over time from investors that have worked with you is your responsiveness, access on nights, weekends, availability on WhatsApp to questions, things that come up. Maybe talk a little bit about that, and also just the scope of your retainer and representation. There's a lot of little steps after the 526E gets submitted. It's not just you mail one thing and then that's it. See you in a few years.
Yeah.
So maybe talk a little bit about that aspect of how your firm kind of approaches it to make it very clear of what the cost is going to be and how you're going to be able to help with all those kind of little interim steps after the main application goes in.
In terms of responsiveness, Sam, I've been called names like AI bot or the woman that never sleeps. We are very responsive around the clock. We have weekend appointments for our existing clients. We accommodate any which way we can. And the reason for that is we want to keep the ball rolling. Again, a 3,000 to 4,000 page file, if I'm sitting on it for 4 weeks, I'm going to forget what the story is. And that's not something I want to do. So we're heavily incentivized to close that file out. We communicate through calls, through WhatsApp, and through emails, but primarily through WhatsApp. There have been situations where my clients have been at the airport, because they used a travel permit and they are stuck in secondary inspection. They'll text me and say, hey, is this going to be a problem? No, I can immediately text back and say, secondary inspection is normal, not a big deal. There's no need to worry. Just sit there, you'll get through, right? Clients need those kind of reassurances when they're traveling or when they're looking to make such a massive investment. Or for example, the client is located in India and they need to speak to you on Sunday night, which is Monday morning in India. We make ourselves available for existing clients. We bend over backward because, again, this is a firm built by an immigrant who's been through the anxiety of the entire immigration process, and it took me 15 years to get here. So I just hope to make it smoother and painless for my clients. In terms of retainer, we are incentivized to do things the right way the first time. And the reason I say that is our retainers do not have an inbuilt fee for RFEs. If there's an RFE, it's because USCIS lost the documents. It's not because we failed to document something. And we want to make sure that we're incentivizing ourselves to put out the most perfect file we can so that there is no RFE. I'm not going to name names. There are other firms that do it differently that'll have a lower base cost and that will build in the RFE fees hourly, or a base fee for RFEs. To each their own. I do think that we have a medium pricing model, but we want to make sure that there are no RFEs. And if there are RFEs, that's on us. We cover that. That is not something we pass on to the client. We like to see it in advance. We like to close all the loopholes, which is why we go the extra step. of trying to understand what USCIS may request and try to document that in advance before it's requested. Again, like Sam said, 526E being filed is not the end of the story. It's the beginning of problems with USCIS. And I say that because so much has changed since the Reform and Integrity Act. USCIS has been losing documents. USCIS has been losing photographs. USCIS has been losing entire files. We need to be prepared as attorneys so the client isn't freaking out about that. The client knows we've submitted everything, but if a copy of the file is on Dropbox and say I'm not available, the client has the ability to print that file, ship it off with the RFE. It's not rocket science. If the client has, if USCIS has lost pictures, which they have in 70% of the time, we've now started requesting additional pictures from the client so we can just ship out the RFE as soon as we get it. Some instances we don't even talk to the client because, hey, there's an RFE on photograph, ship it out. You have the photograph, let it go. The response comes back, it's an approval, the card is there. I think it's very important. Our business philosophy is we don't want to keep the client waiting because we understand that it comes with a lot of stress. The entire immigration process after making so much investment comes with a lot of stress. So in our initial consults, we try to warn clients about the pitfalls, what's to come, you know, what receipts can they expect, how there's going to be a transfer of 485, how the 131 is going to be adjudicated, whether they're going to get a combo card, whether they're going to get a 5-year EAD, a 2-year EAD. I think it's important to work with someone who's done this day in and day out so they know every single scenario that can go wrong and you can plan for that.
Got it. Okay, I think I know this webinar was, you know, targeted more toward Canadians, but you know, a large portion of your clients and our investors are Indian. So, you know, if I'm an Indian investor in the U.S. on H-1B, or you know, I'm an Indian investor, you know, born and raised in Gujarat, in Mumbai, you know, or in Ahmedabad, you know, why would I want to hire you as opposed to some other EB-5 attorney to help me with my application? You know, for those Indian clients in the U.S. or abroad, and not even in India, but also abroad, you know, in other countries, but who may be bringing funds from India, you know, what do you bring to the table that, you know, kind of makes it an obvious or, you know, easier decision to go with you to help them with their petition?
I think that's a great question, Sam. And again, being in the industry for 11 years, what I have noticed is when clients do have Indian source of funds, we do a lot of cleanup work for attorneys that have previously filed Indian source of funds for lack of knowledge, right? And what we've noticed the practice is when Indian source of funds is involved, the attorney is either coordinating with the CA in India or is coordinating with a co-counsel here who understands Indian documents. And then you now have a 3-way conversation between that accountant in India, between the immigration lawyer here and the client as well. So it's a massive ping pong. But my background, I was educated in India until the age of 18. I can read and understand Hindi, Gujarati, Punjabi, Marathi. These are the 4 languages that I can read, write, you know, and understand. So if I'm going to order translation on a certain document, I'm not doing it because I don't understand what it says. I'm doing it because I think it's absolutely necessary for the client to have this document. We don't have to wait for the CPA in India to wake up to say, yes, this document says this. I'm now going to communicate it to the attorney to let him know what it means. We also understand the local country rules. What I mean by that is, what is the W-2 equivalent in India? It's Form 16. Right? What does an Indian tax return look like? It has acknowledgement and a worksheet. If you just provide the first page, you're going to get an RFE. What are the rules around sale of agricultural property in India? Right? Is that taxable? If it's not taxable, we want to specify that to the US government so there is no RFE on tax returns. Right? What do inheritance documents look like? What are laws for intestate succession, right? If there is no will, your family members passed away, what are class 1 heirs? What are class 2 heirs under the Indian law? What are gift laws in India? All of this awareness. What is the document retention period in India? Most of the world has a 7-year period. India has a 10-year period, right? So we tend to have to go back longer in documenting those. Gifts from blood relatives are tax-free, you know. I get questions like, hey, I do have my dad has land in India. Can he transfer the land to me? I sell the land and then invest those funds. That's a bad tax decision because if your father has land and he's liquidating it and gifting you the funds, that's not taxable. But if you're in the US and the land's being transferred to you and you're now selling it, you're paying taxes not only in India, but in the US too. These little things that are just not within the purview of a lot of attorneys that have not operated out of India or understand the Indian source of funds. I think similar thing also applies to Canada, Sam, is Canada has a really high tax rate. And so what ends up happening is most of our Canadian clients tend to take out loans from their corporation. So they're not taxed at this massive tax rate, right? And that's a perfectly okay strategy as long as you can document that the money earned by this corporation is legal, that it's been filed with the CRA, that these documents are available on the CRA website, that the loan is properly accounted for, the loan is payable to the company. If all of that is done properly, there are no issues dealing with USCIS. So whether it's, understanding what the Indian local rules are or what the Canadian tax structure is, we have 11 years of experience in doing this that we can answer any question without a third party being involved in the conversation.
Got it. Okay, that makes a lot of sense. All right, I think that generally covers everything we wanted to get to today. I think for investors who are interested in exploring more about an EB-5 investment, for additional details on any of the projects that we discussed, please reach out to us. Our information's there on the screen. And for anything source of funds related, to talk about documentation, kids' ages, timing, work and travel permit, eligibility, all of those questions, immigration related, please reach out to Anita. She's very accessible. You can text her, WhatsApp, email, all of that, or go to her website and schedule a call. And yeah, thank you for taking the time to join us for today's webinar.
Thank you.